On Monday, April 27, 2026, in a federal courthouse in Oakland, California, a jury is going to be seated for what is now formally called Musk versus Altman. The case has been on the docket since November 2024. The number on the cover sheet is $134 billion. The defendants are Sam Altman, Greg Brockman, OpenAI itself, and Microsoft as a co-defendant. The judge is Yvonne Gonzalez Rogers. The way this trial is structured tells you something important. This is not going to be a normal jury trial. On Friday, April 24th, 3 days before opening, Judge Gonzalez Rogers approved a request from Musk's lawyers to drop most of the case. Out of the 26 claims Elon Musk filed in November 2024, only 2 survived to trial. The first is unjust enrichment. The second is breach of charitable trust. Every fraud claim against Altman, Brockman, and OpenAI is gone. The fraud allegations that have been the loudest part of Musk's public messaging for 18 months are not the case the jury is going to hear. What changed is the strategy. Musk is no longer asking the court to make him personally rich. On April 7th of this month, his legal team filed an amended set of requested remedies. The new asks are these. Remove Sam Altman as CEO and director of OpenAI. Remove Greg Brockman as president. Force Microsoft to disgorge the gains it made from the for-profit conversion. Unwind the for-profit corporate structure entirely, and restore OpenAI to its original nonprofit charter. The $134 billion damages figure, if Musk wins it, goes to the OpenAI charity. Not to Musk. Not to XAI. To the nonprofit board. OpenAI's lawyers responded with a single word in their filing. Ambush. They told the court Musk had spent 2 years framing the case as a fraud, and now wanted to try a completely different theory in front of the jury. They asked the court to dismiss everything. The judge said no. The case proceeds Monday. The structure of the trial matters more than the headline number. Gonzalez Rogers split the proceeding into 2 phases. In Phase 1, the jury hears the liability evidence and issues a verdict. That verdict is advisory. Both remaining claims, unjust enrichment and breach of charitable trust, are equitable claims under California law. The judge, not the jury, will make the final ruling. In Phase 2, the judge alone decides remedies. There will be no punitive damages. The jury will not be told what Musk is asking for. The lawyers cannot mention dollar amounts during the liability phase at all. So the question on Monday is not who pays. The question on Monday is who controls one of the most valuable AI companies on Earth. OpenAI is currently valued at roughly $852 billion and is preparing to file for an IPO this year. If the judge rules for Musk on equitable remedies, the corporate structure the IPO depends on does not exist anymore. Here is the timeline the jury is going to be walked through. December 2015, Musk and Altman publicly launch OpenAI as a nonprofit AI lab. The founding statement says the lab will pursue artificial general intelligence, quote, unconstrained by a need to generate financial return, end quote. Musk donates roughly $44 million in the first 3 years. He sits on the board. February 2018, Musk leaves the OpenAI board, citing a conflict of interest with Tesla's autonomous vehicle work. March 2019, OpenAI creates a capped profit subsidiary and accepts a $1 billion investment from Microsoft. The cap is initially set at 100 times return. Musk is no longer at the table when this happens. Discovery has now produced the email traffic between Musk and Altman across that entire stretch. One thread from February 2023 has been quoted in multiple court filings. Altman writes to Musk, quote, I don't think OpenAI would have happened without you, and it really fucking hurts when you publicly attack OpenAI, end quote. Musk writes back that the fate of civilization is at stake. By November 2023, Musk is publicly saying he is worried about Microsoft having unfettered ownership of AGI. By November 2024, the lawsuit is filed. The 2 surviving claims are narrower than they sound. Unjust enrichment under California law requires the plaintiff to show that someone received a benefit at the plaintiff's expense, and that it would be unfair to let them keep it. The benefit, in Musk's framing, is the value Microsoft, Altman, and Brockman extracted from the conversion of a charitable asset into a for-profit asset. Breach of charitable trust is the older theory and the more dangerous one. California recognizes that when assets are donated to a charity for a specific purpose, the people running that charity are fiduciaries. They cannot redirect those assets to private gain. That is the doctrine Musk is trying to apply to the OpenAI restructuring. The judge has already ruled on what evidence the jury sees. Dr. Stuart Russell, the UC Berkeley computer science professor who literally wrote one of the standard textbooks on artificial intelligence, has been cleared to testify about safety incentives at Frontier Labs. The court excluded his most extreme catastrophic risk testimony as unduly prejudicial, but he can testify about why a charitable AI lab and a for-profit AI lab face different incentives. Dr. Paul Wazan, the damages expert, has been cleared to walk the jury through the methodology that produces the $134 billion figure. The witness list is the part that is going to drive the cable coverage. Elon Musk will testify. Sam Altman will testify. Greg Brockman will testify. Ilya Sutskever, the former OpenAI chief scientist who briefly tried to remove Altman in November 2023, will testify. Satya Nadella, the chief executive of Microsoft, will testify. 5 of the most powerful people in the global AI industry are about to be on the same stand under oath in the same courtroom in the same month. The implication of all of this is broader than one company. If Judge Gonzalez finds that OpenAI's directors breached their charitable trust by converting assets to a for-profit subsidiary, every other AI lab that started as a nonprofit and pivoted is exposed to the same theory. The model of starting a research mission, gathering tax-advantaged donations, and then quietly restructuring around a profit motive is now legally testable. The result of this trial is going to set a precedent that every general counsel at every research lab in the country reads on the day it lands. The political layer is uglier. Musk is now the founder of a competing AI company, xAI, which is currently raising at a valuation in the tens of billions of dollars. OpenAI's legal team has openly described the case in court filings as a, quote, harassment campaign driven by ego, jealousy, and a desire to slow down a competitor, end quote. That framing is now part of the trial record. The jury is going to hear it during opening arguments. Whether it lands depends on whether the jury believes Musk's redirected damages, the new ask that all winnings go to the charity instead of to him, is sincere or strategic. The financial stakes for Microsoft are easy to underestimate. Microsoft has invested approximately $13 billion in OpenAI through the capped profit subsidiary. Microsoft has booked tens of billions in implied equity gains. If the court orders disgorgement, the entire investment thesis is on the table. Microsoft is also currently in a separate business dispute with OpenAI over the recently announced $50 billion Amazon AWS cloud deal, which OpenAI signed without Microsoft's knowledge, and which arguably violates Microsoft's exclusive infrastructure rights. A court order that breaks the for-profit subsidiary breaks the contracts the AWS deal was layered on top of. The other quiet piece is security. Earlier this month, an individual described in court records as AI-averse threw a Molotov cocktail at Sam Altman's home. Altman was unhurt. Federal authorities are investigating the case as a targeted attack. Both Musk and Altman are now expected to enter the courthouse with private security teams of historically unusual size. Musk's team has previously used decoy Tesla vehicles for arrival. Expect the same in Oakland. The trial is being held in a federal courthouse with metal detectors and armed marshals. So the things to watch over the next 4 weeks are these. 1. Whether Musk himself takes the stand and what he actually says under cross-examination. 2. Whether Sutskever's testimony about the November 2023 boardroom revolt becomes admissible in detail. 3. Whether the advisory jury comes back for Musk on either of the 2 surviving claims. 4. Whether Judge Gonzalez, who is not bound by anything the jury says, rules anyway for the structural remedy Musk has asked for. Mid-May is the expected verdict window. The most valuable private company in artificial intelligence is going to be on trial for its existence the entire time. Stay sharp. Jane Sterling, Sterling Intelligence.